Hello, welcome to Federal Sector News, the State of the Union. Today, September 1, 2025. I'm Merrick Masters, Professor of Business Emeritus. It's Labor Day. I want to thank all those federal workers for all of the time and effort and talent they bring to serving the American people. Today's episode deals with the impact of executive orders removing various agencies and departments from the Federal Service Labor Management Relations statute protections on grounds of national security. We're looking at the impact that these orders may have had on the union's ability to collect dues, focusing on 4 unions that we've surveyed for the largest federal employee unions. Executive Order 14251, Exclusions from Federal Labor Management Program, was issued by President Trump on March 25th of this year. It removed several major agencies and departments from the protection of federal labor law on grounds of national security, which included the Department of State, Department of Defense, Department of Treasury, Department of Veterans Affairs, and the Department of Justice. On August 28, 2025, President Trump issued an executive order adding some additional agencies to the exclusion from the Federal Labor Relations Program protections. They included the International Trade Administration, the Patent and Trademark Office, the National Weather Service, and the U.S. Agency for Global Media. The status of implementation of 14251, in addition to the executive order and its subsequent amendment, the administration has also issued guidance on how to implement the order. And as a result, it has canceled contracts in various federal agencies and departments and stopped collecting dues per dues checkoff arrangements that had been previously negotiated with the unions. And it's also withheld the use of official time for conducting union business while terminating the use of agency facilities for such purposes. Selected federal employee unions' net revenues and member-based income. This table reports the net revenues for 2024 from the air traffic controllers, National Federation of Federal Employees, American Federation of Government Employees, and the National Treasury Employees Union. It also shows the revenue that it derives from member-based income or dues, taxes, and fees. The air traffic controllers, for example, raise 86% of their net revenue from member-based income. The National Federation of Federal Employees raises only 11% from its member-based income. The American Federation of Government Employees raises close to 87% of its net revenue from member-based income, and the Treasury Employees Union raises over 92% of its net revenues from member-based income. The number of members reported in 2024 by the unions and their bargaining unit coverage as reported in FedScope as of February 2025 is included in this table, and it shows, for example, in the case of the National Federation of Federal Employees, that only 17% of the members are part of their bargaining unit is made up of only 17% members. In the case of the American Federation of Government Employees, it's 39%. In the case of the National Treasury Employee Unions, it's 62%. That is, its membership is equal to 62% of its bargaining unit representation total. In the case of the air traffic controllers, they actually have more members than they do bargaining unit represented employees. It's been reported in various court documents, which are cited here, that the executive orders excluding agencies from federal labor management protections has had a significant impact on 3 of the union's revenues, or will have over the course of the year. National Federation of Federal Employees Union reported that in a recent pay period, its allotted dues intake declined 58%. AFGE reported that in a recent pay period, its allotted dues intake dropped by 82%. And NTU estimates that it will lose $25 million over the next year in its dues intake due to the removal of labor rights on grounds of national security. The Office of Personnel Management recently released a study on taxpayer-funded union time compensation government-wide, and it shows that in fiscal year 2024, the total compensation spent on union representation or official time was over $207 million. This is something that the Trump administration is interested in putting a stop to. I came across a very interesting article in one of today's issues of Government Executive, which is a commentary by Ronald Sanders and Robert Tobias, two well-known figures in the area of federal sector labor management relations, and I recommend it for your review. It states, among other things, that while we, I'm quoting from the article now, come from different sides of the federal bargaining table, we both support collective bargaining in the federal sector because we believe in it. Without question, they say it is the most effective workplace problem-solving mechanism devised by our government. They go on to specify their bottom line conclusion, which is the actions of the Trump administration are unnecessary, unjustified, and not in public interest. They should be rescinded either by the president himself and or by the Congress. The president's actions have been subject to a variety of complaints filed by the unions. Some litigation has been decided by preliminary courts. Ultimately, this will have to be determined by the U.S. Supreme Court. And even if it's determined by the U.S. Supreme Court to uphold what the administration has done, it's likely to be revisited by Congress at some point in time in the future, particularly if it is Democratic controlled.